Hi, I am N.S.Syama Prasad. I am going to give you some questions and answers. Actually, it is called question hour. I am going to ask you 10 questions and try your luck if you will be able to answer all these questions correctly. I shall give the correct answers. I shall explain why this is the correct answer. For example, first question I am asking you is, which amendment of Indian Constitution provides that a governor can be appointed for 2 or more states, or a high court can be established for 2 or more states? Which amendment provides for this? The right answer is 7th Amendment of Indian Constitution. 7th Amendment passed in 1956 during the period of Jawaharlal Nehru as the Prime Minister, passed this 7th Amendment. We know we passed the State Reorganization Act in 1956 and we created 14 states and 6 union territories. That was created by an act of parliament. But later it was decided we shall amend the constitution also. And this amendment provided that a government can be appointed for 2 or more states and a high court can be established for 2 or more states. You can see, if a government is appointed for 2 states, the expense will be divided between the 2 states as the president will decide. Similarly, high court, there may be a high court for 2 states or sometimes 3 states, etc. We have 3 high courts. This exercise jurisdiction over 2 or more states. You know, Punjab and Haryana have the same high court. Maharashtra and Goa have the same high court. Assam, Andhra Pradesh, Nagaland, Mizoram have the same high court. 3 high courts exercise jurisdiction over 2 or more states. This is provided by 7th Amendment of Indian Constitution. And you must see, Delhi is the only UT that has high court of its own. Jammu Kashmir, Ladakh, 2 union territories have the same high court. Other union territories are affiliated to nearest high court. Lakshadweep is affiliated to Kerala High Court and Pondicherry is affiliated to Madras High Court. Next question is, as per anti-defection law, suppose an allegation of defection is against the Speaker of Lok Sabha, who will decide this? Normally, Speaker will decide. But if the allegation against the Speaker, who will decide this? The right answer is a member elected by all members of the House. I shall explain this. We know we passed the anti-defection law in 86 during the period of Rajiv Gandhi. And this anti-defection law was added as 10th schedule of Indian Constitution. And the anti-defection law applies only to members of Parliament and members of state legislatures. It does not affect Vice President because he is not a member of the Rajya Sabha. But we can affect the Speaker of Lok Sabha, Speaker of Assembly, etc. So, if there is a complaint against any member of the Lok Sabha, that is decided by the Speaker. Whether he has defect or not, that is decided by the Speaker. Suppose the allegation against the Speaker, who will decide, that is the question. The Act says, if there is allegation against the Speaker or the presiding officer, one member selected by all members will decide. So, in the case of Speaker, only such a provision is there. Speaker cannot take the decision, therefore, one member elected by all members will take the decision. That is the second question. And next, third question. The word cabinet was added to Indian Constitution by which amendment? The word cabinet was added to the Indian Constitution by which amendment? We know the right answer is 44th Amendment. 44th Amendment, 1978, passed during the period of Morarji Desai, added this word cabinet in the Constitution. Normally we use the word Council of Ministers. Only in one article you can see the word cabinet. That is in Article 352. Morarji Desai's government made a small change in Article 352. This article now says, if the President is to declare national emergency, there must be a meeting of the cabinet. The cabinet must decide to declare national emergency and the decision should be communicated to the President in writing, then only the President shall declare national emergency. Only in Article 352 you can see the word cabinet. So that was added by 44th Amendment during the period of Morarji Desai. Hope is clear. Next question. What is meant by epistolary jurisdiction of the Supreme Court. Epistolary jurisdiction. Epistolary jurisdiction. Yes, epistolary. Epistolary jurisdiction means the power of the Supreme Court or the High Court to entertain complaints or petitions received on a piece of paper, in a postcard, or in telegram, or in the newspaper. That means the court can take action on the basis of complaint sent to the court by a person in a postcard. That means by spending 2 or 5 rupees you can move the court. That is the essence of public interest litigation. Anybody can file some complaint to the Supreme Court or High Court. The complaint may be sent in a piece of paper. If it is a genuine one, the court will entertain this. That is known as epistolary jurisdiction of the Supreme Court. That is entertaining public litigations sent on a piece of paper, a postcard, or telegram. That is known as epistolary jurisdiction. Epistola means a piece of paper. That's why it is called epistolary jurisdiction. Next, how long present rule can continue in a state? We know present rule can be imposed by the President under Article 356. How long it can continue? National emergency can continue for any length of time if the situation remains the same. Financial emergency can continue for any length of the time if the situation remains the same. But in the case of present rule, there is a limit. Maximum 3 years. Normally, present rule is for a period of 1 year. It can go beyond 1 year if 2 conditions are satisfied. 1, there should be a national emergency. Second, the election commission should certify that it is not possible to hold election due to certain difficulties. If both conditions are to be satisfied, then it can go up to 3 years. Otherwise, normally it will continue only for 1 year. Next question. Under Article 22, preventive detention without the permission of the advisory body, how long a person can be kept under preventive detention? Article 22 provides for preventive detention, and there must be an advisory body. If a person is kept in preventive detention, advisory body must agree to this. Then only he can be under this preventive detention for a long time. So how long a person can be under preventive detention without the approval of the advisory committee? The right answer is 3 months. Even though by 44th Amendment it was reduced to 2 months, as the rules have not been framed. So even now it is 3 months. The period is 3 months. Next question. In which case, Supreme Court said, a person cannot be subjected to narco-analysis test or polygraph test, etc. without his consent. You know, Article 20, subsection 3 says, nobody can be asked to give self-incriminating evidence. So, asking a person to give evidence under narco-analysis test is against 23. Therefore, the case came before the Supreme Court, and the case is known as Selvi versus State of Karnataka. In this case called Selvi versus State of Karnataka, the Supreme Court, at that time held by Justice K. D. Balakrishnan, declared that a person cannot be subjected to narco-analysis test or polygraph without his consent. If that is forcefully kept under tested by this, that's against Article 20, subsection 3 and Article 21. So remember, the case is Selvi versus State of Karnataka. Next question. Which article of Indian Constitution is known as Doctrine of Pleasure? Doctrine of Pleasure. Doctrine of Pleasure. Doctrine. D-O-C-T-R-I-N-E. Doctrine of Pleasure. The article is 310. Article 310 is Doctrine of Pleasure. Doctrine of Pleasure means Every central government employee holds office during the pleasure of the president, and every state government employee holds office during the pleasure of the governor. That is known as doctrine of pleasure. But that does not mean anybody can be removed simply by the president and the governor. There is a protection given to them by Article 311. Protection is that nobody can be removed from service or nobody can be reduced in rank when authority is subordinate to that by which is appointed. Similarly, when a person is to be removed from service or when a person is to be reduced in rank, he must be given an opportunity to be heard. That is provided in Article 311. So, doctrine of pleasure is mentioned in Article 310. Next question, the Right to Information Act came into force from which date? Often this question is asked, the date on which the Right to Information Act came into force. The Right to Information Act came into force from 12th October 2005. 12th October 2005. And last question, the Constitutional Review Commission appointed by central government was headed by, who was the chairman of the Constitutional Review Commission. Chairman of Constitutional Review Commission. And remember, the Constitutional Review Commission was appointed by Vajpayee government in 2000 and it gave report in 2002. It was headed by former Chief Justice of India, Justice Venkatachalaya. Justice Venkatachalaya was the chairman of Constitutional Review Commission. So we have discussed 10 questions. Now one question I shall give you. If you know the answer, you can post it in the video. Post it in the video. Otherwise, I shall give you the explanation in the next class. My question is, the first nominated member of Legislative Council who became the Chief Minister of the state. Normally, nominal members are not appointed as ministers or chief minister, etc. But you can see a nominal member was an MLC nominated to the Legislative Council became the Chief Minister of the state. And try to get the answer. If you know the answer, give it in the comment box. Otherwise, in the next class, I shall give, next question of class, I shall give the answer and I shall explain why this answer is correct. I shall give a hint. That was in 1950-152 period. 52, a person was appointed Chief Minister. Find out who was the Chief Minister, nominal member of State Legislative Council who became the Chief Minister.